Hello, everyone, and welcome to episode 35 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. It is May 12th, 2020, and as of today, it has been 9 weeks since the first case of COVID-19 arrived in Michigan. I'm Lisa Kirsch Satawa, and for those of you who are just tuning in or are new, we do this every day at 1 o'clock. And we have some really interesting things to talk about today. Really, a lot of the topics that we use come from the people who watch by either sending us questions or making comments or suggestions on the Facebook page or sending me a private message. And it's great. I love your input. Please keep it coming. So good afternoon to everyone. It's freezing here. I actually have this really snuggly blanket around me, but I wanted to be outside anyway. Fresh air is a great thing. So let's talk about what's in our air tonight, as they say in one of my favorite songs. There have been 4,584 deaths in Michigan, which is up 33 from yesterday. It is the lowest increase since March when COVID arrived in Michigan. There are 47,552 cases, which is up 414 from yesterday, which does not make me really happy. It's interesting that we now have 22,686 people who fall into that recovered category, which just means that they haven't been symptomatic for 30 days. It doesn't mean they don't have it or they're not carrying it. Michigan is testing 15,000 people per day, which is the highest number per day testing of any state in the United States. We are also testing more of our prisoners every day than any state in the United States. We now have 30 labs open in Michigan, where, if you recall, 9 weeks ago, there was one. So a lot of the supplies, a lot of the influx of people to step up and assist and help and convert their businesses, it's all paying off, and we can tell by the numbers as we look at it today. I wanted to talk for a minute about what's going on in the Michigan Department of Corrections. There were 225 people paroled last week. 273 people are expected to be paroled this week. 253 people are expected to be paroled the next week after that, and then 303 people paroled after that. So you hear those numbers, and as a citizen, you're like, wow, why are they letting all these people out of prison? Well, I did a little digging for you because, I'm all about the information and the statistics. And no one is being paroled early because of the virus, and no one is being paroled early because of any special accommodations. People are being paroled at a faster rate. The parole board, which is the body that makes the decision if someone is safe enough to be released and to be in the community and what services are necessary, is just holding their hearings and their interviews, and they're working literally 24 hours a day, 7 days a week, so that they're processing faster. It's not that people are getting a special break when they're not ready. Some things that about the parole process. If you remember, a couple weeks ago, we talked about the difference between a jail sentence and a prison sentence. And a prison sentence is indeterminate. That means it has an earliest release date and a maximum date. And a person can be released anytime between their earliest release date all the way up to their maximum date. So if someone has a sentence of 2 years to 5 years, at the 2-year mark, they would be eligible to be released. However, they have to satisfy a bunch of other conditions in order to be released. When they get to the maximum number, the 5, they must be released. And so basically, the law says that a prisoner shall not be given liberty on parole until the board has reasonable assurance, after consideration of all of the facts and circumstances, including the prisoner's mental and social attitude, that the prisoner will not become a menace to society or to the public safety. So because of that, while people are in prison, there's, certain programs available, and it could be substance abuse treatment. They'll look at that. They'll look at to see how the person has adjusted socially in the prison environment. Have they gotten in trouble? What programs have they availed themselves of? What are their plans if they're released? Do they have family support? And there's basically, the process is there's an interview, a report is generated, there's a public hearing before the parole board, which are now being done remotely, and then a parole decision is made. Things that are happening in prisons because of COVID-19, as I said, they're working faster at processing, and they're not letting out more people or different criteria than they were before. It's just there's more being processed. There is no transfer between facilities right now, unless there's approval of the assistant deputy director of the MDOC or a higher official. That means that if someone was in quarantine in Jackson, which is where everybody goes as soon as they're sentenced to Michigan Department of Corrections, they go to what they call quarantine classification, and they would still be remaining in that facility. They would not be transferring to the prison that has the proper security level or proper programming, or wherever they're going to actually serve their sentence. They're kind of stuck in this little purgatory area. And they go through a process of evaluations there, psychological evaluations, medical evaluations, and other factors or parameters to determine which classification, security level they need. And again, programming. For example, a lot of sex offenders go to the facilities that have the sex offender treatment program. Now, most facilities have substance abuse programs. If it's someone who has a high school diploma or GED, they may be put in a facility if they want to take some college courses or earn a college degree. They might go somewhere where that's available. Or if they have an interest in a certain vocational skill, that may be what plays in. So other things that are happening as a result of COVID-19, as I said, all the parole board interviews are now happening remotely. They're not happening within the facility. Now, this is probably the most important thing to tell anyone who is either listening with a loved one in the prison system in Michigan, or someone if you're preparing for them to go, or if you're an attorney and you just want to advise your clients of this. JPay, which is kind of the mail service, mail order catalog it's like the Amazon of prison, is continuing to offer 2 free stamps per week through June 2nd, 2020. And GTL, which is another one of those kinds of services available, is providing 1 free 5-minute phone call every 7 days for the first 2 weeks of May 2020. Sorry about that. Tipping here, trying to be organized. And for the entire month of May, GTL will reinstate the internet and mobile fees at reduced rates to prisoners. And just so that you have an idea, it costs someone $2.95 transaction fee to make a phone call from inside a prison. So they're reducing that to $1.95, and the 95-cent transaction fee is also being eliminated, so that people have more access to their loved ones while they're incarcerated. even though they cannot visit. And so now I'm going to switch gears here. And as we talked about yesterday, we're learning, or we're talking about, I guess, we're not really learning. But this week we're kind of focusing on kids in court. And today I wanted to, this is based off a question we had yesterday. The question came from someone who their adult child, was involved in a custody battle, and also involved in that was in a divorce, and also involved in a child protection proceeding for termination of parental rights. And in each of those proceedings, a guardian ad litem was appointed for the child. Ordinarily, if they were in the same county, that would be one person who participated in both. However, they were in separate counties, one in Oakland, the child protection proceeding, and one in Tuscola, the very highly contentious custody battle as part of the divorce. So there are two ways to look at guardian ad litems, or lawyer guardian ad litems as they're sometimes called. And that is, there's a very, very vast amount of experience. There's a very vast amount of training. There's a very vast amount of involvement. There's a very vast involvement in advocacy, and it is totally inconsistent all over the state, from case to case, from GAL to GAL, from LGAL to LGAL. It is really concerning to me when I'm on a case that has an LGAL or a GAL, or if I am one. In Michigan, we do have a protocol that was authored in August of 2015, and it outlines right from the statute and the court rule what the responsibilities are of someone who represents a child in court, and the difference in the title of your appointment. It's important to know that parents cannot hire an attorney for their children in either any type of custody case. So in whether it's in a divorce case or whether it's a child protection proceeding where parental rights are at issue, the court must appoint this person. It doesn't mean that the court is going to pay for this person. It depends on the financial standing of the parties. But the court will choose this person. So let's look at the 4 different ways a child can have a representative in court. And again, we're talking about family court now. We are not talking about delinquency cases. We are not talking about the juvenile criminal cases. So it can be a lawyer guardian ad litem, known as an LGAL. And an LGAL must be a lawyer, and their purpose is to determine and advocate for the child's best interests, and then to inform the court of the child's wishes. The child's wishes and their best interests may or may not be the same. Then there is an attorney who can be appointed for the child. And that person is going to advocate strictly for the child's wishes, not their best interests. A lawyer guardian ad litem is going to do a neutral investigation to determine what those best interests are. And we'll talk about that in a minute, what that means. And then as I said, the attorney, because they're an advocate, will have the typical attorney-client relationship with the child, where they'll have confidentiality and loyalty, and their expressed wishes will be conveyed to the court. Then you have a court-appointed special advocate. That's a CASA, is what it's most frequently called. And CASAs are used regularly in some counties and not so often in others. I think that it gets really complicated when you have a lawyer guardian ad litem and a CASA. But depending on what is at stake, you have to have a lawyer guardian ad litem in a child protection proceeding. You do not have to ever have a CASA. They're volunteers. They're very lovely people. They are trained by different charitable or nonprofit organizations. And this volunteer will investigate the child's circumstances and make recommendations to the court concerning the best interest of the child. This is the issue. Although they have training in the law, they don't necessarily understand the application of the law. I have found that they can be extremely helpful in getting information and doing interviews of like the teacher, the best friend's parents, some of those types of sources. They can do very well at getting background information. They provide written reports to the court, where I have run into difficulty with court-appointed special advocates when they're on my case, is that they are making best interest determinations for the court, recommendations to the court, and a lot of their training does not fully encompass what the consequences of those recommendations will be. And they tend to not be nearly as neutral as either a guardian ad litem or an attorney guardian ad litem, where there's nothing presumed and there's no bias there's not supposed to be in those types of investigations, where sometimes with court-appointed special advocates, there may already be a finding of abuse or neglect before they're involved. There may not be, but there may be an interview. They're not trained in how to analyze an interview of a child, how to look for factors that make it more accurate or reliable versus factors that make it more suspect. So, as I said, they are lovely people. I never, ever would say, no, I don't want one on a case. But sometimes it does make the case more confusing. And it's another cook in the kitchen. And then there's just a guardian ad litem as opposed to a lawyer guardian ad litem. And that's someone who pretty much does the same thing as a lawyer guardian ad litem, but they're not a lawyer. And so their duty is to the court. And for example, I was appointed to, even though I'm a lawyer, to be a guardian ad litem, not a lawyer guardian ad litem, on a case in Wayne County several years ago, where after it was in a divorce case, there was a custody battle, and after 19 days of testimony at trial, the judge did not have a reliable picture of this child's health issues and if they were medication compliant, what the diagnoses were, who the treating doctors were. And so I was appointed as a guardian ad litem to investigate that one issue on the case and report back to the court. And then he used that information to make his custody determination of what was in the child's best interests. So sometimes if you're just a guardian ad litem, I shouldn't say just because it's a lot of work, but if you're a guardian ad litem as opposed to an attorney guardian ad litem, you may be, your duties may be narrowed by an issue set by the court, which can also happen with the other one, but it doesn't happen very often. As I said, there are court rules and statutes that come into play when we're talking about guardian ad litems and talking about their responsibilities. And as I said, the kind of case is what will dictate really what to expect. The guardian ad litem or lawyer guardian ad litem, I'm going to use them interchangeably right now for the rest of this. But it's the attorney lawyer guardian ad litem that I am mostly referring to. And that person has to visit with the child, build rapport with the child. They have to see the child before every court hearing. The child does have a right to be in court, but it doesn't happen often for really children under like 12. And it really doesn't happen very often even with children who are older than that, unless they really, really, really have an issue and they don't have a great relationship with the lawyer guardian ad litem, or if they want something that is different than what the lawyer guardian ad litem thinks is in their best interest. Because in that scenario, then they want to come to court and they want to say, Judge, no, I don't want to do that. I want this. And so the other thing that can be done on the child's behalf, and this is really, in what I've seen in the last 26 years, really underused. Lawyer guardian ad litems have the ability to ask the court to pursue other issues on behalf of the child. And that comes right out of the statute, which is MCL 712A.17 D1J, I believe. And basically it says that they can intervene in the child protection proceeding if they're appointed in a custody proceeding. They could intervene in a guardianship proceeding, a paternity proceeding, termination of parental rights, adoption, appeals. They can get authorization from the court and payment from the court to deal with issues like Social Security or public benefits, if they were involved in personal injury, if there's a lawsuit, school and education issues, especially for a child with disabilities. You can participate in the IEP, go to conferences, talk to the teachers. If there's mental health proceedings, name change proceedings, if there's anything with issues with medication, doctor's appointments, abortion, estate planning, employment, camp, the guardian ad litem can intervene in all of those with permission of the court. And their responsibilities last until they're discharged by the court. So it can last for a long time. And I'm just kind of looking to see if anyone's posting any questions about this stuff. I'm just going to scroll for a minute and see. Nope, not right now. Hello to everyone who's sending me messages. It's nice to see you all. I'm so excited that you tune in almost every day. And I hope that, like I said before, that you'll leave comments on the page and send me your questions and your topics. I just wanted to take a little quick, I think I hit everything I wanted to tell you. I mean, I have tons I could tell you about guardian ad litems, but I think that I pretty much hit the big issues. So with that, oh wait, I have a question. Okay. In our son's child custody case, in the tribal court, the GAL not once ever, met with him. How could that GAL have, I'm trying to read this. How could that GAL have remained neutral in that case? Ultimately, they ruled to terminate without the GAL or the Child Welfare Commission ever meeting or talking with our son. could the fact that our son's ex-wife was their tribal court administrator have anything to do with that? It just doesn't seem fair. Well, and that's how I started this when we started talking about guardian ad litems. And it's not fair because it's not consistent. And, I would love to say that when someone involved in a child protection proceeding is in a position within the legal system that it doesn't matter. But that is probably not accurate or real. I can't really comment on measures that can be taken or measures that were taken in an individual case. But I know that if I was involved in representing someone in a jurisdiction where someone had that close of a tie to that court and to that jurisdiction, I would be filing the motion to move it to a different county, a different circuit, a different tribal court. Tribal courts have their own rules. And for those of you who don't know, in a custody proceeding, a child protection proceeding, anytime a parent's rights are at risk of being terminated, the tribe is considered a party, and the tribe has just as many rights as the parents to raise those children. So they're very complicated how ICWA, which is the statute that, and MICWA is the Michigan Indian Child Welfare Act, how that works. But they're always included if it's an Indian child, and that means they have Native American affiliation. And we talked about, actually, a few days ago, when we talked about what happens when Protective Services knocks on their door. One of their policy questions is always if the child has any Indian heritage, or do either parent identify with any American Indian tribe or Native American tribe. And so that's for another day. So that's what I was talking about earlier about the guardian ad litems, and I wish every single one of them would really, truly do their independent investigation, be neutral, and truly determine what's in the best interest of the child, and not just say, because these parents are accused of something horrible, they shouldn't be parents again. We talked about it before. I'm going to say it again. All parents have a constitutional right, a fundamental right to raise their children. It's a right we have to fight for. It's a right that we have to respect. And it's a right that God knows in that delivery room has been earned. So with that, I am going to finish today by giving you the 5 reasons not to harm your loved ones during quarantine. And it is, I feel like all of you could recite them with me at this point together. Number 1, protective services workers are essential. Number 2, law enforcement is essential. Number 3, our prisons and jails are a breeding ground for COVID-19. Hard to self-distance and hard to have any safety precautions to the extent that you would have them on the outside. Number 4 is that parents can be punished for kids being kids. And number 5, of course, because barely anyone, if anyone, looks good in horizontal stripes. So with that, I will say goodbye and have a wonderful, wonderful day. And we'll continue talking about children in court tomorrow. And we'll talk about it in the criminal or delinquency setting as opposed to in the abuse and neglect, child protection, and custody divorce setting. So that's what we're going to do tomorrow. And please send me messages, like our page. And I hope you're all safe and healthy and home. And I'll see you tomorrow. Bye-bye.